The odds that a person with intellectual disabilities being interrogated by law enforcement would be read and given their Miranda rights and sign those Miranda rights, understanding them in 60 seconds flat. In September 2003, Andy Royer was visited by Detective Conway. Detective Conway drove Royer from Royer's apartment to the Elkhart County Police Station. Conway, in his report, said that he presented Andy Royer with his Miranda rights at 9:34 a.m. and Royer signed and waived his Miranda rights at 9:35 a.m. If you waive your Miranda rights, you have just waived your right to have an attorney present while you're being interrogated. Let me just say this. The Supreme Court of the United States has said that it is imperative for a person under interrogation to understand their Miranda rights. Otherwise, there's literally no point for the requirement that law enforcement present certain persons with their Miranda rights. Royer would end up being interrogated over a 2-day period. And the Supreme Court of the United States also has a problem with the way that Royer was interrogated. Because, see, if a person doesn't have time to get away from the police, to get away from the investigation, to get rest, to consult with family members, loved ones, an attorney, then the Supreme Court has said that that is a nonstop interrogation. And guess what? Royer subsequently confessed to the murder of Helen Saylor. Miss Helen and Andy Royer lived in the same apartment complex, the Waterfall Rise Apartments. And that apartment complex, it is designated for the elderly and people with disabilities who qualify for public assistance. Confession to a crime that results from nonstop interrogation and or not properly knowing your Miranda rights, well, that is a coerced confession. Now, by the time this is all done, an Indiana post-conviction relief court will have found that Detective Conway, that another Elkhart County sheriff, that they fabricated evidence against Andy Royer and another woman, Lana Kanan, and that a friend of Lana Kanan's was coerced into implicating Lana. Royer and Lana Kanan would eventually be charged with murder and they would be tried together. Not only did those defendants have to deal with this coerced confession from Andy Royer, but there was a fingerprint expert who said that Lana Kanan's fingerprint matched a print found on a pill bottle, a medication bottle at Helen Saylor's apartment. Okay, get this. The fingerprint expert was not actually a fingerprint expert. So not only did the post-conviction relief court find that Detective Conway and another Elkhart County sheriff had fabricated evidence against Royer, had coerced a witness to implicate Lana Kanan, but the fingerprint expert also committed perjury because he wasn't actually a fingerprint expert. Years after their convictions, Indiana State Police retested that fingerprint and excluded Lana Kanan. She was released before Andy Royer was released. But Royer, after spending, I've read everything from 16 years, 17 years, and 18 years. We'll go with 17 years in the penitentiary. He received one of the largest settlements for a wrongful conviction from Elkhart, Indiana. To be exact, Royer received $11,725,000. Royer said that financially, he's free, that he can help his family members. But we all know that nothing, no amount of money will give him back the 17 years that he spent in prison.